That's for me?
Yep.
All yours.
You're welcome to sit anywhere. You suggest that.
Today, yes.
How's everybody?
This is not a tough ground.
God, there's 50 different languages in schools. Good afternoon, Your Honor.
Hi.
Good afternoon, Judge. I have the privilege and honor of being the chairman, and let me tell you what the protocol is going to be. It's pretty straightforward. Each of the commissioners will introduce themselves. One of our commissioners, Amanda Perry Carl, is attending by telephone, and she is here today. After the introductions, you'll have 2, 3, 4 minutes, whatever you need to give us a brief opening statement, anything you want to share with us. We'll then have about 20 minutes of Q&A, and I've got the job of being the timekeeper.
Okay.
And so we'll stop, and then you have an opportunity to make any closing remarks you'd like to make.
Okay.
Then get started.
Good afternoon, Your Honor. Vincent Citro, at the Law Office of Fort Winston Citro.
Craig Dyer, Public Defender's Office, 7th Street.
Andy Bardos, Greg Robinson.
Again, Michael Sasso of Sasso and Sasso, and I have Commissioner Amanda Perry call appearing by phone.
Brett Renton, Johnson Boner, Orlando.
Nice to see you, Your Honor. Petra Brownlee, the Brownlee Law Firm.
David Diarmas, Kramer Price and Diarmas, Orlando.
Your Honor, Scott Thomas with Byrne Foreman.
Hi, how are you? All right. Hi, everybody.
Yes.
So nice to talk to you all. Most of you again, some of you for the first time. I have to start just by thanking you all first, and thanking you for your service on this committee. It is an incredible opportunity just to be sitting here. Like, this is something I will remember for the rest of my life. It's part of my career. So the idea of just being here is tremendous. I'm nervous. I noticed the flags at half-staff, and so they've really taken an emotional pivot for me this afternoon. As you know, from New York, and I used to work down there. I went to law school down there. I went to law school to work at the United States Securities and Exchange Commission. That was my dream job. I put all my eggs in one basket, and I didn't get that job. And I didn't know what to do, and somebody had said to me, well, you know, if you become a prosecutor, they sometimes lateral you in. And so I said, oh, I'm going to apply for a prosecutor because I don't give up, and I'm going to keep working at it. And so I got this job at the Miami-Dade State Attorney's Office. And it just shows you that this is the plan B. Sitting here before you is my plan B. And what an incredibly somber day to be here, remembering everybody as an American, as a New Yorker, even though I know that's probably not my best quality.
Judge, I'm from the Bronx.
Yeah.
You're good.
So, you know, that I wanted to just take a minute and acknowledge that today is a very somber day and very meaningful to me. So, that path took me to the Miami-Dade State Attorney's Office 20 years ago. 20 years ago this week, I was checking my bar exam results on something called the internet, right? And I had just started at the State Attorney's Office in Miami. I had just gotten assigned to my first criminal courtroom ever. And I had just learned the most important lesson of my professional career. For 20 years now, it's still the most important lesson I ever had. And that was to go to the statute books to find out what the law said about what to do. It was the only thing that got me through being in a Miami courtroom, or any courtroom. So fast forward to when I was at the Attorney General's office supervising all these lawyers, and they would come to me with issues on their cases and asking me, what do we do? And I would grab for the statute book and open it up, and I would ask them, what does the statute say? And even now as a judge, even though the statutes are online, I still reach for the statute book and open it up to see what it says so I can figure out what to do. So I love the law. I'm tremendously adherent to the text, and I really do have a desire to write, and that is why I applied, and that's why I'm here today. Thank you, and I'm welcome any questions you have.
Judge, my name is Craig Dyer. I've introduced myself. I had the pleasure of meeting you, and I do have a question concerning when you were with the Attorney General's office. indication that you were senior assistant general counsel from 2003 to 2004, and then bureau chief from 2004 to 2015.
Correct.
How was it that you went from 1 year in the Attorney General's office to bureau chief?
You'd have to ask the people that gave me the job. I was along for the ride. I'll tell you, on my first day, I walked in and my secretary pointed to the corner office and said, "That's yours." And I went in it and sat down and began running the office even in 2003, March 2nd, 2003. So I really even had the job as bureau chief, almost acting bureau chief, when I was designated senior, and then officially given the job. I guess maybe they wanted to make sure I could do it, but I would be speculating. But I really did have all the responsibility from the first day.
Most everybody I talked to was very impressed with the way you did handle it, and particularly were fond of the fact that you could be trusted no matter what happened. If they asked you a question, the answer you gave was the correct answer. But I do have questions as to your references, in that you listed several references who were impossible to get hold of.
Yeah.
Carlos Munoz of the Florida Supreme Court, Senator Lemieux, several other people who didn't return phone calls. Were they aware of the fact that you were going to be using them as references?
Yes, I reached out to every one of them. They are all people that I worked for at the Attorney General's office, that I personally interacted with. They were all, as the bureau chief, it was the bureau chief, then maybe 1 or 2 deputies, and then the Attorney General or director, and 1 or 2 deputies, and then the Attorney General. I was briefing the deputies always. Carlos Munoz was Justice Munoz was a deputy that I briefed on cases. Former Senator Lemieux was a deputy that I briefed on cases. So I also had other people make calls as well that could testify to my daily interaction. People that I have letters, recommendation letters in my file that of people that worked for me that also testified to my work at the Attorney General's office. I thought that would be an issue, but they represented to me. I reached out to them and asked them if they wanted to still be references, and they said yes. They support me, authenticity.
What would you say your judicial philosophy would be?
My judicial philosophy is pretty simple. I rely on the words in the statute. I let the words speak for themselves. I think the most important part of a judge's role is judicial restraint, and that applies everywhere. Applies differently maybe in different trial versus appellate court, but judicial restraint, I think, is one of the most important things, and the respect for the separation of powers as part of checks and balances, and the judicial restraint being a self-check.
Do you believe that it is important for a 5th District Court of Appeal judge to have to send a message to the legislature that it's time to change the law?
I would have a hard time doing that. I would have a hard time even considering a special concurrence to the Supreme Court. I just would have a hard time with that.
Judge, there have been several openings, several vacancies rather, on the Ninth Circuit Court, the Ninth Judicial Circuit. Did you put your name in for any of those?
Why not circuit?
Yeah, I truly didn't know for sure whether you did or not. And if not,
No,
why?
not yet. Not yet.
Is there any reason?
Well, no, it's just not something that has come into my path. I'm open to wherever my path ends up right now. If you're asking me, do I think I should go to circuit before I apply to the appellate court? I think every court is different. I think the role of the circuit court, or trial courts, as you may, is very different from the role of an appellate court. The role of the appellate court being error correcting on specific issues briefed and argued before them. It's a whole different kind of review, and as I was alluding to before, a very different kind of judicial restraint. I'm a trial judge now, and I'm having a really good time. I enjoyed criminal. I just got assigned to civil. I'm having a really good time learning the little nuances in civil insurance, PIP, all the other things that I'm handling right now. It's not off the table. It just hasn't been something that was drawn to me yet.
What is it that attracts you to the different function of the appellate bench that you'd seek that out?
Yeah, so the one thing I know for sure, I mean, looking back, I'm a very reflective person. No, I don't think anybody wants to apply to this job as just for whatever reason. I really made sure I wanted to be here. And I do want to be here, but it took a lot of reflecting. Why? Why do I want to be here? Why not circuit court versus an appellate court? And I realized in 20 years of litigation, the things I loved the most was not the trial. It was the research, the prep, the strategy, reading the case law to figure out whether I was going to win a motion to suppress or lose a motion to suppress, or summary judgment motion. All the pretrial motions were the things I really enjoyed. The trial was probably the thing I enjoyed the least because it's so uncontrollable, you know. It's very different. It's a very fact-finding, you know, kind of process. Whereas the appellate court is more connected to those pretrial motions, or at least that's the way I look at it. I really enjoy the legal issues. I love the motions to suppress. I love hearing them now as a judge. Those are my favorite parts of what I do. Like in civil now, I enjoy the statutory interpretation. In criminal, I love the motions to suppress. Those are the things that intrigue me most. I get really excited about them. And if I'm reading case law all day and it's coming from the Fifth, that's how I ended up saying, well, if I love this so much, why don't I consider just reading case law and considering these issues instead of the trial? So, and I could be wrong, but so far I feel like I'm on the right path.
Judge, what would you say, given your relatively new civil assignment, has been the most challenging thing for you in that assignment, and what about it made it a challenge? I mean,
Without a doubt, it's the volume. The challenge is the volume. And I think that goes with life. Everything is easier if it just comes at you a little slower. I don't know how many thousands of cases there are. That's the hardest thing, is just being prepared for things, and then the things, you know, you think you're prepared for one thing, and that you spend 3 hours preparing for a motion, and that one settles a half an hour before, and you only prepared 45 minutes for the other thing, and that one's going. So I think it's just a matter of balance. And I'm only there 9 months now. I'm hoping that I get better at it. Caseload management used to be a thing I was really good at. Obviously, coming from Miami, I handled 400 felony cases set for trial. I managed the AG's office, so I'm hoping, I have faith in myself that I'm going to get better at it. So.
Judge, do you think it's important that applicants have practiced sort of on both sides of the table that they've represented? If criminal is going to be the field, that we should look for applicants who have represented both the state and the defense? Or should that not be relevant?
I mean, that's up to you. I think the most important things are how they approach the role and whether they are going to exercise judicial restraint and interpret the statutes as they were written. I think that's the most important thing. Everything else, I think, is really taking a back seat.
What's your view on PCAs?
I have understand that the practitioners want to understand after they put in all that work, and I think as a general rule, you should write. That's why I'm here. I want to write. I understand that, you know, if you can't communicate by writing, perhaps communicate with a citation. At the end of the day, again, the volume is an issue, and sometimes writing more doesn't help. Sometimes more words is not better. So, you know, as a general rule, we should write to clear up issues.
Or to explain the ruling, there is a ruling here.
Correct.
I spoke to Judge Grossens about, yeah, you used her as a reference, and she said that while you were employed with the state and the Attorney General's office, that you were known for holding people's feet to the fire, okay? In light of the PCA question, and the judges were talking about PCAing something, would you hold their feet to the fire about writing an opinion?
I would disagree with her. I would not say I hold other people's feet to the fire. I would say I hold my own feet to the fire, because it's my responsibility to follow the rules. So if that ultimately requires other people to be more prepared because I'm following procedure, then I think that I would agree with.
Well, let me add what she said. She said you won't let them slack off.
But I mean, I won't slack off. So your question, so I understand it is, if I'm on.
In light of the fact that somebody doesn't want to write and you feel there's a necessity to write, will you try and convince them to write?
Or I will write.
Uh-huh.
I mean, I can do my best to convince. I think that's the whole collegial atmosphere is more of a discussion on refining issues and positions and ideas, and through that process, I would hope we would all come to an agreement, and if we don't, and I feel the necessity to write, I will write.
Judge, if you can, if I had the power to just put you in charge of creating, if you will, a list of best cases, right, a hall of fame, if you will, best cases ever written, federal, state, doesn't matter. Put together your best list, and then the hall of shame, worst case decisions in your opinion. What cases come to mind?
How many do you want?
At least 3.
Okay. In either category?
Both categories.
Oh, okay. All right, so the most important one would be a very recent case out of the first DCA, Rosier v. State. That
In
case,
best or worst?
best,
Okay.
best, 100% on point. Any appellate judge should memorize it before they have their first assignment. It was an en banc hearing where they reversed the panel, where the panel found that the trial court judge had made fundamental error with the competency hearing's adequacy. And the en banc hearing found that the panel had sua sponte reached into the record and brought this issue out of fundamental error. It was never briefed, it was never specifically briefed, it was never briefed. And so the en banc panel reversed the 3-judge panel. That is a very incredible case that I think is the most important. And it just came out 2 months ago. Specifically, Judge Winiger's concurring opinion goes through the importance of judicial restraint in the appellate role, and that it is, and he cites to Justice Kennedy's, I think it was his dissent in DH. So does that count as my second case?
If you want it.
So,
Your list.
but what's great is that in the concurrence, he goes and gives like 6 bullet points of why it doesn't work to do that, and why judicial restraint is important, and what does that mean to review the issues properly before, specifically argued and briefed before the court, properly preserved, even though fundamental error doesn't need to be preserved in the record, but it needs to at least be briefed, specifically briefed and argued. Otherwise, it changes the whole role of the appellate court. Okay. You don't know what the court's responsible for doing, and it creates more chaos. So I thought that case should count for all of the cases that you want me to cite, but I have more. I thought that on the U.S. Supreme Court, there was an interesting case, Garza v. Idaho, that extended the Sixth Amendment right to counsel. It extended it to the effective right to counsel, which I thought was interesting. I don't necessarily agree with that. I think I agree more with, I think it was Thomas and Gorsuch who dissented in that case. Another Florida case, I didn't really agree with. I agreed with Justice Kennedy's dissent, and that case was Joyce v. Federated Insurance. Had to do with a contingency multiplier, and Kennedy said, look, there's just no competent evidence in the record to rely on this. We don't know how the court got there. So I thought that was another interesting case.
Judge, can I ask you something
Sure.
before you, I don't want to, you're on a really important track.
I'm making a list. Yeah.
I know, and I don't want you to like forget a third because I interrupted, but it has to do with one of the cases, so I feel
Yeah.
like, so I read the Garza against Idaho, but I did it so long ago, so I'm wondering, is that the case where they say, are you agreeing that the word, like, for example, in the Sixth Amendment is not effective assistance of counsel, it's just
Right.
assistance of counsel?
It's just assistant of counsel. They added effective assistance. Where did this word effective come from? That was the extra word, an extension of something that wasn't there before.
So can I just ask you, okay, so imagine that effective, okay, it's not in there, and so we shouldn't read into the Sixth Amendment that you're entitled to something that you're not. But then what does the right to counsel mean? I mean, the right to a person who, a shell of a person who's not gonna faithfully advocate? I'm just wondering,
Yeah, that's a great
why
question.
isn't it absurd, basically?
Right. Our whole system of government is set up in checks and balances everywhere. Just as I was saying before, even in the judicial role, there is a self-check. That is how our system works. So the Constitution says right to counsel. I'm sure there are other places for an individual to have real representation. That's why you have the Florida bar. That's why you have the appealable, Rule 3s of ineffective assistance of counsel. There are other avenues to have issues, legal issues, due process issues litigated. So without studying that whole area more, which I'm not familiar with, I would say the other checks and balances are there, and really it is not the place to be squeezing words into the Constitution for a fix for that particular situation in that case. Does that make sense?
Yes. I think though, if you're gonna bring like an ineffective assistance of counsel claim, if that's one of the alternate avenues that you could go, I guess I'm just lost on, well, how do you argue you're entitled to relief based on that if the word effective isn't in the Sixth Amendment?
Right. I don't know. I'd have to look at it more.
Yeah, and fair enough.
But I honestly think if we look through it, adding a word to the Constitution isn't the way.
Right.
And I'm sure we could figure out other checks and balances that would save that situation without having to start adding things to the statutes or to the Constitution.
I see.
So,
I could talk and debate it for hours. Next time, sorry about that.
that's fine. So Rosier also, we're all going connected back to Rosier because it's so important, especially here today. So Judge Winiger cites Judge Rosehand's dissent in a case from the Fifth called Bourbon v. State. Basically a similar situation where the court court sua sponte finds an issue in the sentencing and Judge Groshand's dissents along the same reasoning that we should not be acting as extra counsel to appellant or reaching into the record, going past issues that were not briefed and specifically argued. So that's another case. Are you numbering them?
Too good, too bad.
Too good, too bad.
It's tough.
I liked Gamble, the Gamble v. U.S. another. I thought that was fascinating. I love how Justice Thomas talked about stare decisis forever and ever and ever, and then went along with it. And then Gorsuch dissented. I wonder how much more evidence Justice Thomas needs to dissent. Like, what are we gonna do? We're gonna go back 200 years. What else can we find? So I thought that was a fascinating opinion by both of them. Trying to think, what else did I read? I read so much.
Well, that's fine.
Give somebody else, give somebody else a chance.
Put time to waste. And ask your other question.
You're hogging the clock, dude. We're a rough crowd.
The day is late.
I want to get a question. Your whole career, you've been very active, interacting with lots of people. Now you're a judge in Florida. And I know from a family connection what it's like to work up here, which is kind of new anyway, but this is a very quiet place. It's a very monastic type existence.
Yeah.
Do you, obviously you're applying, so you want that, but how do you think you would transition from being a bureau chief, trial judge, wham, 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 your phone probably lights up every 15 seconds, emails, texts, and all of a sudden slows down and have a more contemplative existence. How do you think you'd handle the transition?
Yeah, so you don't know me very well, because I dream for that. I'm actually very, very introverted. So people said that about when I became a judge. They're like, oh, you're gonna really not enjoy it. It's very isolating, and to me, it's not isolating enough. I'm a hermit. I don't eat lunch. I sit in my office. I read, or I try and go for a run or something. But I'm a loner. I've never really been a big joiner, and I think I would enjoy it very, very much. So I'm really introverted. I'm one of those weirdos that are the outgoing introvert or something. So I'll be fine.
Anybody else? Okay. Having no seconds, thank you so much for coming. This is your opportunity to make any closing remarks or comments you'd like to make to the commission.
All right, well, thank you so much again. I want to just express my gratitude for being here today. It really is a tremendous opportunity. As a first-generation American, especially today, I think the most important thing that you're looking for is someone who is going to let the statutes speak for themselves, let the words speak for themselves, and someone who is going to exercise judicial restraint and understands the appellate role is an error-correcting role where we review the issues specifically briefed and argued, properly preserved before the court, and that is the judicial restraint that I would apply. I know we didn't talk about it, but on the county bench, not a lot of people watch. Sometimes there's not even lawyers, sometimes it's just pro se. I enjoy it very, very much, but I am a rule follower there too. I exercise judicial restraint when nobody is looking, and I know that I would be doing the same thing on the appellate bench as well. And I thank you for your time.
Thank you, Judge.
Thank you so much for
Yeah,
coming.
safe-
Thanks.
safe ride home.